first paragraph at the top of page 35. When he completes to execute his motion, he does not invite anyone to even second. Records are there. But we see one Honorable Major Golicha now standing up to second the impeachment motion. Who has invited him? There's no one. And other members, strangely now, so the House is suddenly in an autopilot. So from Honorable Major, then we see the Speaker opening the floor. You have Honorable Peter Losu. He continues. Without the intervention of the Speaker, there is another member, Honorable Salesio Kiambi, who proceeds as if the Speaker is not in this House, as if the clerk is not in this House, and proceeds. Another member just rises up. From nowhere, there is no recording of the Speaker inviting any member to make a contribution to this motion. Apart from, of course, page 39, when suddenly the person cooking this answer realizes the Speaker has not been captured in this, and now we see the Speaker for the first time. In conclusion, because I do not want to take time that my senior is going to take to address you on the other issue, look at page 41. After the members purportedly complete to make their submissions, the Speaker makes very strange remarks, and I quote at page 41. Clerk, is the governor or his legal representative available? Sergeant at Arm, can you check around if the governor or his legal representative are present? The Speaker does not even take time to communicate to the House whether the governor had been invited. He does not even read that invitation notice as required. So why is he calling for the governor, whom Learned Counsel had told you was invited to appear at 9 and we at 2 o'clock? The Speaker is not seen anywhere saying that we invited the governor by this letter and he has not come, but instead asked the clerk to check whether the governor is available anywhere. Let's proceed. I'm completing, Honorable Senators, and this is going to shock you. So, when the governor was confirmed was not in the House, the Speaker proceeds to guide the House on the next move. At the end of that page, 41, I read what the Speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the Speaker shall, this is the Speaker telling them, the Speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the Speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell. Is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors Through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is participate actively in court proceedings, and this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist, because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly before the new Constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, And you'll find that ruling starting at page 165 of volume number 4 of the governor's documents. But the relevant part I would refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I will then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I'm always impressed by the support we get from the administrative teams in this Senate that may have to go on record in the interest of posterity. At page 13 of volume number 4 is a decision of the court in Isiolo High Court constitutional petition number A004 of 2025. The parties are Honorable Abdi Ibrahim Hassan, the governor now before you as petitioner, and the County Assembly of Isiolo now before you as the first respondent. There are two other parties in that matter, but safe to highlight that the parties before you are parties in that suit. They are therefore bound by the decision of that court. At page number 25, Allow me to just go straight, Mr. Speaker, to page number 27. You'll find a paragraph 28 of that ruling. And the judge observes as follows: it is important to note that there was no complaint raised when the first orders were issued by the court in respect of the motion dated 10th June 2025 that was to be debated on 17th June 2025. In fact, the sentiments by the mover of that motion, the contemnor, actually vindicates the court, as he has in his affidavit conceded that the motion was defective in substance and marred with procedural irregularities, the very grounds that the petitioner has sought to rely on. The mover of this motion went to court and told the court, it is true that the orders you gave first were right, because the motion I had tabled was marred. It was defective in substance and marred with procedural irregularities. The move of the motion. Allow me to then take you to paragraphs